Hello again, everyone, and welcome to our workshop today with our presenters from Vermont Family Network, Disability Law Project, and EdLaw New England. I'm Janice Sabat, a family support consultant with Vermont Family Network, and your host for today. We're glad you're joining us for the fourth of 8 events and workshops we have in our Persevering in the Pandemic online learning series. If you missed any of our earlier events, you can check out and find the links on our website. We do want to take a moment to recognize and thank our sponsors for our online learning series, which you see here on this slide. Vermont Family Network has been serving families of children with special health needs and disabilities and the professionals who serve them for more than 30 years. We are the federally designated Parent Training and Information Center, the Family to Family Health Information Center, and the Vermont chapter of both Family Voices and Parent to Parent USA. And now I'd like to have our presenters introduce themselves.
Hello, I'm Marilyn Mahuske. I'm a staff attorney with Vermont Legal Aid's Disability Law Project.
And I'm Rachel Seelig. I'm also a staff attorney with Vermont Legal Aid's Disability Law Project.
I'm Greg Van Butzen. I'm one of the attorneys at EdLaw New England, and we represent parents in Vermont and New Hampshire.
And Karen, if you could introduce yourself.
Okay, and I am Karen Price, and I work at the Vermont Family Network. I am the co-director of special education.
Okay, and before I turn this over to the presenters, wanted to let you know that this workshop is being recorded and we're going to save it on our website and our YouTube channel. Everyone who registered for today's workshop is going to get the follow-up email that'll have the link to the webinar as well as a link to the PowerPoint that the presenters used. As far as asking questions, feel free to chat any questions or comments in chat as we go along, and our panelists will be looking at those. If you want to ask your question out loud, you can use the raise hand feature and we'll unmute you and you can ask your question then. And both of these functions you'll find at the bottom of your screen. And now for our presenters.
So we're here today to talk about how to provide public comment on the special education rules. And the reason we're doing this is the special education rules are currently open and are having some changes being considered. The special education rules are rules that schools must follow in order to provide special education in a way that complies with federal law, in particular the Individuals with Disabilities Education Act. There are actually 2 kinds of rules. There are federal rules that are written by the United States Department of Education. That's not the rules we're talking about today. There are also state rules, and these are rules that are run through the Vermont Board of Education. And these rules do all sorts of different things that have a lot to do with the experience that children and families have in the special education services that they receive. The rules dictate how we identify children with disabilities, how we assess those students, how we decide who's eligible for special education and related services and supplemental services and aids. They also dictate how we run our IEP meetings and your rights to things like having notice before a meeting and getting a written notice after a meeting if the team didn't agree. And they talk about how IEPs need to be written and the process that we need to go through to change IEPs. These are just some of the topics that the special education rules cover. And so if there are challenges that people are experiencing with special education, one of the ways to try and address those challenges is by asking for changes to the rules, because the rules, once they're approved, they have the same effect as a law that's passed by the legislature. They are enforceable in court, and so they're pretty important. And they're not changed all that often. The last time that the special education rules went through any changes was 7 years ago in 2013. So this is a pretty special opportunity to be able to share experience and talk about how the rules could be changed in order to make special education better for students across our state. Next slide. So you might be wondering, what is public comment? And public comment is part of an administrative process that says that the government can't just change rules without hearing from the people. They need to give an opportunity for anyone who wants to give feedback or make suggestions, the opportunity to be heard. So anytime the rules are being changed, whether it's about special education or another topic, this is a process that whoever is considering changing those rules has to go through. And so it's not meant to be a really complex process. We're going to talk later about how to make public comment. But it is really, it's a formal term for giving people the chance to talk about what is in the rules and what should change in the rules. And one of the things that's important to know is that we want to make sure the Board of Education hears from as many people as possible so that they can understand that the issues that people are raising are issues not just for one or two people, but are issues for a lot of people. Because the more they hear from you, parents and students and loved ones of students with disabilities, the more they will be able to understand why changing the rules to make special education better is so important. Next slide.
So Rachel, can I jump in here for a second? I know you're going to talk about what the issues are, but I think it might be helpful for folks to have a sort of an understanding of part of the reason that we're doing this presentation is that as Rachel said, the Agency of Education has submitted a set of rules to the State Board of Education that they are asking the State Board of Education to change. And a group of advocates, including us, had gotten together and reviewed all of the special education rules and proposed substantial changes to the rules. And so what we're talking about today are some of those changes that we, as parents, as advocates, who represent students and parents with disabilities, think are important to make the access to special education more effective for students. So I just want to make sure people have that background. And so that's the reason why it's important for you, if you're a parent, particularly if you're a parent of a student with a disability or an educator who cares about this, that you understand that there are competing rules here. And it's helpful if the state board hears from people who are affected by the proposed changes, or if you're looking at the agency's rules, that they're rules that, you know, don't go far enough really in terms of addressing some of the important changes that we feel need to be made to make education more available to kids with disabilities. So sorry for interrupting, but I realized we didn't have that sort of context.
That's a really good point. And I actually think that kind of really leads well into the list of the issues that we have here.
Though Rachel, may I also interrupt just because it seems like a good time, that we really do want to encourage parents to speak, because I have provided testimony. And I think that for the State Board of Education to really hear from real parents with real children who are directly affected by, you know, informal words on the regulation is impactful. Because when parents are talking about their own children, it becomes real that these are regulations that affect what happens to children right now. And if they were different, there could be a very different impact. So it is different when they are hearing from, you know, state level, you know, players where everything's theoretical, and hearing from parents where it's not theory at all. It is reality. This is how it affects your child in school. So we really, really do encourage parents to provide public comment.
And that's part of why we wanted to have this workshop today, to talk about what are the issues that we think need to be addressed and how do you provide public comment? Because for a lot of people who aren't in the roles that we are in at Legal Aid, at Vermont Family Network, at EdLaw New England, it maybe is not something you've ever felt the need to do. You know, it has maybe not felt so connected to your life. And so we hope that this will end up making public comment feel really accessible, because that's what it's supposed to be, is an easy way for people who are just part of our community to have a say in the rules that govern our special education services. So this list that's on the slide right now is a list of topics that we, the folks who are here as your presenters, have identified as areas in the rules that we think need to be changed, but that are not part of the proposed changes that the Agency of Education has presented. And so we're going to go through them one by one and talk about why we think they're important, the kinds of comments we've given on them, and the kinds of comments that families might consider providing on these topics as well. These don't have to be the only topics that a parent or a student or another loved one of a student provides comment on, but these are ones that we as advocates who've worked with a lot of families have seen as being issues that we think need rule changes to fix. So I think we can move on and start with our first topic, which is adverse effect.
Okay, everybody. Hi, my name's Greg, and as Rachel said, we tried to identify some of the most important issues for this workshop. One of those issues that comes up all the time for us who work with families and for families themselves is the rule around adverse effect. This is basically the rule that decides which students are eligible for special education and which students are not. It's a very important rule because right at the beginning, if the decision is made that a student is not eligible, then that student is not going to receive an IEP. The rule as it's currently written is unfair. And the essential reasons are that in order to be eligible for an IEP in Vermont, regardless of what disability you may have, you have to show an adverse effect in an academic area, such as the ones listed here, like oral expression, listening comprehension, writing, reading, math. But if you are a student who is struggling socially, emotionally, behaviorally, or just functionally, like being able to attend school, maybe you have severe anxiety, maybe you have difficulty pulling it together to get assignments done, you don't know where to begin. None of those things are considered in the current rule. And we all feel strongly that needs to change. Mm-hmm. If you agree that that needs to change, then it would be great if you would contact the state board and let them know.
Mm-hmm. You know, another piece of that, Greg, is just why, you know, we think it's unfair. And I think that's a really important point to make. I think it's also helpful for people to understand that that's not the federal rule, that Vermont's rule does not reflect the federal rules. And as Rachel said at the outset, special education is based on federal law and federal regulation. And the definition of how you determine whether or not a child qualifies for special education or related services under federal law is not this, that Vermont's rule is more restrictive. And so one of the things that we have done in preparing and proposing the rules that we've prepared is that we wanted to, we proposed changes throughout the rules where there was a conflict or there was not consistency between the federal rules and Vermont's rules. And this one is the one that really jumps out and has a profound effect on kids' access to special education.
I think the next slide talks about what Vermont Legal Aid is proposing in terms of fixing this rule.
Okay. So in terms of fixing the rule, as Greg said, that you notice that there's under Vermont, we have a 3-gate system. And what we are proposing is a 2-gate system. And this is where the 2 gates is consistent with what the federal requirements are. So the first, in order to qualify under the federal rules and under the Vermont rules, is the student needs to be determined to have a disability under one of the disability categories. There are 13 categories of disability. That we're not proposing be changed. But we are proposing that the gate 2 be eliminated, and we are proposing that Vermont, like most other states, go directly to gate 3, which is looking at whether or not the student needs special education to benefit from their educational program, when the supports that the student needs can't be provided in the general educational system with appropriate supplementary aids and services. We think it's simple. Aside from being consistent with federal law, it allows the team to look at any of the issues impacting a student's ability to benefit from their education. And Greg gave some examples. If you have a child who has significant anxiety and just going to school in and of itself, getting out of bed and out the door is challenging, that impacts their ability to benefit from their education. Children with emotional disabilities often don't have an adverse effect, or maybe even kids on the autism spectrum don't have an adverse effect on their academic performance, but they have, there's an effect on other aspects of their ability to learn and to be successful. So we're suggesting, this change in part because it's going to address some of the needs that kids have, and we think it's fair and it's inclusive, and it addresses the inequity that we have in our current system.
So I see a couple questions in the chat that maybe we need to do a little clarifying.
Okay.
One is, how can Vermont have adverse effect when it's not consistent with federal law? Isn't that illegal?
Well, the federal government, the federal system is the floor. States are not allowed to do less than what federal law requires. In some areas, states can do their own thing as long as it's not less than federal. But we believe that what Vermont is doing right now is inconsistent with federal law and is also discriminatory now in the way that Marilyn said, where it's excluding from eligibility students who might be students on the spectrum, or students with emotional issues, or students who have trouble with all these non-academic issues.
And I see, are there historic reasons Vermont set up eligibility this way?
Go ahead if you know the answer.
Well, way back in the day, it used to be that, I'm talking about, the federal law first came to be in 1975 when it was the Education of the Handicapped Act. So it's been around a long time. And for a time, there was a focus on learning disabilities, more focus on learning disabilities than on all the other types of disabilities, like emotional disabilities, or hearing impairments, or traumatic brain injury, or all the other 13 categories that Marilyn mentioned. When the focus was on learning disabilities, it made sense to look at issues like basic reading comprehension, or math calculation. But that's an old, outdated, restrictive way of looking at all the students nowadays who have lots of other disabilities. And now you can see on these elements on the right side about interpersonal relations and independence and teamwork and decision-making. These are all skills that we want all students to have in school and in life, after school. And now that's a big part of education in Vermont. So clearly, we need to update this whole system. But that's how it came about in the past. There was a focus on learning disabilities, and there wasn't enough focus on other things.
Someone also has raised a question, it looks like, as to if we were to make this change, essentially the question is, does it open the floodgates? And, our view is
I don't think it does. I mean, one of the things that I've seen is that when teams have to spend a long time figuring out, is there adverse effect? what happens is they spend very little time looking at the question of, does the student need special education services? And one of the big changes that we're anticipating, part of the reason these rules are open, is the implementation of what's called Act 173, which says all schools need to have a multi-tiered system of supports. So there are some students where if we can intervene early, they might not end up needing special education services. But one of the challenges with adverse effect is if a student is not found eligible for special education in kindergarten or first or second grade, the challenges that they experience don't go away. And they actually become, then they have disability related needs that become bigger and harder to serve the more time that we let pass. And so getting rid of adverse effect helps us intervene as early as we can in order to reduce the need for special education for a lot of students over time, because we get them what they need when they need it, rather than waiting for something to be such a big issue that they become eligible with this special adverse effect definition. That's my take on that issue.
And just to add to what Rachel said, if you don't do it early, it gets harder on the student, it gets harder on the family, and it's going to cost more money to address it later.
Right.
So you actually save resources by addressing it early. If you just think about a student who's anxious and depressed and overwhelmed at school and having trouble with relationships and having trouble with school attendance, whatever it may be, if you can get support for that student and address why those things are happening and work on them early, then that student may not need a more expensive, intensive therapeutic intervention later.
We should probably move on to our next slide, just because I know we have a lot of other topics to cover.
Yeah.
I can't remember, Greg, is this mine or yours?
Well, this is just basically saying that on the left-hand side, you can see the basic skill areas are the things that you look at when you're deciding if a student is eligible. Is the student struggling in these areas? And right now, on the left-hand side, they're all academic in nature. And on the right-hand side, the proposal that Vermont Legal Aid is making is to add these other skills we've been discussing. Here they're called functional skills and transferable skills. What those actually boil down to are all the non-academic skills, interpersonal skills, decision-making, teamwork, all the skills that you're gonna need to be successful in school and in life after school.
So next slide, Janice. Go ahead, Greg.
Yeah, these are just examples of what we're talking about. Functional skills, specific daily living, like all the practical things that students need to do just going through the day. Personal things in terms of preparation for the day, just deciding how to go about organizing your day, even personal hygiene, things like that. Social skills, employment skills, and all of these things other than reading, writing, and arithmetic that students now have to get. And the same thing in the transferable skills, there's a lot of overlap between these two things. The transferables talking about work habits and character traits and things to be successful in school, in college, and in the workplace. We think all those things should be part of the analysis when you decide who's eligible for an IEP, special education, and who isn't.
And I just want to briefly, while we're doing this, is answer the question that someone put in here about, you know, have we proposed these changes in the past? And if so, you know, why didn't they go through? And Karen can speak to this better than I can, but we have over the years talked to the agency about opening the rules, and we've always been put off. And so for many years, we've been, you know, raising some of these concerns and issues with the Agency of Education and some other partners. And The reason they're open now is because, as Rachel mentioned, Act 173, with the changes in funding for special education, rules by definition needed to be changed. And so once the rules are open and any changes are proposed, then they're open for comment. So we're sort of seizing the moment and the opportunity to make the changes to better address the needs of kids with disabilities. So sorry to cut in there, but I wanted to just sort of make sure, make that point.
Yep.
So next slide, Janice. And really, we've kind of addressed this, right? Which is that, so I guess to conclude on this piece of it is that by bringing together the adverse effect and having a two-step process instead of a three-step process, and bringing in the looking at functional and transferable skills, we think it's going to make the process fairer and more effective. That kind of sums that up, I guess. We've already said, we need to modernize the process and make it fair and equitable.
Okay, this issue is one that we all identified as problematic in Vermont, which is the issue of parental consent. The idea of informed consent is applicable to many things in life where people give their informed consent to something, whether it's in a contract or whether it's in a relationship or other domains. But it's fairly elemental to say that when you're talking about special education and something like an IEP, there should be informed parental consent. Right now, the way things are, when you have an IEP meeting to talk about the services that a student is going to receive, that the school district is going to propose for that student, an IEP is sent to the parents, or maybe just developed at an IEP meeting, but the parents are never asked for their consent to it. There's no place for parents to sign. There's no place for parents to say, I understand this document and I agree to it. So Vermont has this limbo land where the IEP is proposed but never agreed to. And we want to change this so that parents have a voice and their voice is sought out and listened to, and parents can agree or not agree or partially agree to whatever's being proposed.
I see a question about, have we taken into account new American families? And I think consent is one of the places where that's really important. And in fact, consent should be sought in someone's native language or other mode of communication.
That's a good point.
Next slide.
These are examples of different places where consent is relevant. When there's going to be an evaluation and the team is deciding what to do for an evaluation, when there's an initial provision of special education, when there's an IEP that's developed or renewed, in all of these places, we should be getting parental consent. When all of us who work with families often hear, when we look at the records, we often say to the parents, did you consent to this? And they often say, no one asked us to consent. So it's not like we did or we didn't. We just got this IEP in the mail. So these are places where we could have a clear system for consent.
And the three that we have in bold, those ones are not in our rules right now. So the renewal decision, the annual decision about placement, any question about, are we going to change a student's disability classification, or are we going to change the kind of services or the amount of services? none of those are things where currently our rules say, hey, you need parent consent for this. The other ones, our rules currently say you need parent consent, but as Greg was talking about, it's often really unclear if that consent has been sought or received.
This is a shot of a New Hampshire IEP that does what we're talking about, and it makes perfect sense. The black print there is an actual shot from the bottom of an IEP, which has the parent's response to the proposal. And the language says, please indicate your response. And the choices are, I consent to the IEP as proposed, I refuse to consent, I partially consent, and you just check a box, excuse me. And if you refuse consent, down below, you can say which particular parts you're refusing consent for. You can also write in the changes you're requesting, and you can check a box down there at the bottom to have another meeting to talk about it. This makes perfect, absolute sense, and it would be very simple to incorporate in Vermont. And I love the way that it allows the parents to have a voice here, not just about consenting or refusing, but also to have input and feedback about the document.
And I think that what has Greg just described that kind of addresses the question that I'm seeing on the chat box is consent understanding. It is understanding. You have to, in order to consent to something, you have to understand what it is. And here it's like, well, okay, I agree. I like the way this IEP is written. Or I'm like, well, I like this part of it, but I don't like that part. Can you explain this other part to me more? Or how's that going to affect my child? Or who's going to provide that service and what's it going to look like? And it gives you then, as Greg indicated, that where there are parts of the IEP that's being proposed that you don't agree with, you have an opportunity to get further understanding, or to simply say, no, I don't agree. We need to keep talking about this. We need to come up with something else. And I think one of the things that is an important thread throughout special education is parents are active members of the IEP team. They're critical members of the IEP team. The law is very clear that parents are an important member of the IEP team. And you can't make decisions if you don't understand what it is that you're being asked to make a decision about. And you have the right to ask more questions so that you do understand what kind of services your child's going to be getting or not getting.
Could I ask a question of Karen? Karen, at Vermont Family Network, do you see this issue in your work where you can't tell whether the parents were consenting or not consenting, and they weren't asked to consent or not consent?
Yes, I think that is definitely an issue. And that's why this would, and that it is very murky. As I think Marilyn was pointing out, that if a parent has an opinion about one piece, but where they disagree, but another piece where they don't, there can be a lot of confusion when it's not, when there's no process for providing that clarity. And unfortunately, sometimes when parents call us, they actually don't know what they don't know. So might not even have quite realized what they might have missed. So yes, it's definitely a problem.
Yeah. I can't think of any legitimate reason not to have informed consent as part of the process. Just don't understand how that came to be. I don't know of other states where this happens. There might be some, but I'm not aware of them.
Okay, so this slide is the timelines for special education reevaluations. So currently there is no timeline for conducting a special education reevaluation. And these reevaluations are required once every 3 years, although the IEP team can agree to a record review. So among our proposed changes, we are proposing that the timeline for reevaluations follow at a maximum the same time frame as initial special education evaluations, and that would be 60 days. And the reason for that is that we have seen reevaluations for the families that we work with be delayed for really unreasonable amount of time, especially those reevaluations that are conducted outside that 3-year piece when the IEP team or when the parent has requested that a reevaluation be conducted earlier. Okay,
So,
next. Mm-hmm.
I've heard a question of, well, isn't the timeline that it has to be done by the 3-year reevaluation date? And I think the answer is yes, theoretically, the reevaluation should be done by that 3-year date. But I think one of the things we've seen, and Karen, I'm guessing you've seen this too, is that that does not always happen.
Mhm.
Or if a parent, especially when a parent has asked for a reevaluation to happen early.
Right, and usually those are even more time sensitive because when a parent is asking for reevaluation early, it often is because they have seen their child not make progress, and
Mhm.
where they're saying the IEP really is not, something is wrong, and we need to go back and reevaluate and make sure that we know what's going on with my child, and then to have those reevaluations then sort of get mired with no timeline in sight. It's distressing and really wrong and doing the child a disservice. Okay, next slide.
This one is another common sense change that's being proposed about access to documents before meetings, meaning allowing parents to receive relevant documents 5 days before a meeting. At the moment, there is no requirement for schools to provide parents with evaluations before a meeting. We think that it would be very beneficial for parents to receive documents at least 5 days prior to the meeting. That way parents can review the evaluations. Sometimes the evaluations are quite complex. Parents may need to research things or ask questions or just consider their own feelings about it, look at the student's prior records, and just prepare for the meeting. If they come to the meeting prepared, then they're able, again, to be equal participants, as Marilyn said earlier, instead of sitting there at the meeting trying to read the document at the same time and keep up with the conversation. It's just not possible. So it's another thing that seems obvious. Of course, parents should receive documents before the meeting, and that's what this proposal is about.
Okay, so this is another piece that we are addressing with our list of proposed changes. So currently the transition age in our rules is 16, and this means that the transition plan, which includes transition-related goals and services, be part of a young person's IEP in the year that they turn 16. And the proposed change is that we move that age down to 14 years of age. So why would we want that? Well, 14 is the age that most students are entering high school, and adopting a long-term view at that point, with an eye to transitioning out of school, can influence a student's coursework and make it jive a little better there. This would also be in line with the rationale behind the Personalized Learning Plan, or the PLP, which is in effect for all students. So moving the transition age to 14 would also align with the work of vocational rehabilitation, and it could open up more career and post-secondary preparatory activities for a young person with a disability. Post-secondary outcomes could be definitely strengthened with a transition plan that begins earlier rather than later.
And I think one of the things about transition for parents who maybe are on this webinar but aren't yet parents of students who are of this age is that transition age students may not need the same kind of transition services at 14 as they do at 16 or 17 or 18. But having that be part of the plan and being able to have that kind of long range thinking is really key to having special education services lead to being able to have a job or go to college or do some other kind of post high school educational program. If you don't start preparing early, then there's not enough time left when a student is 16 necessarily to have them do that level of career exploration and trying different kinds of jobs and that sort of thing. So it gives the students the time they need to have meaningful access to that transition period.
It's also a good opportunity, going back to the basic skill areas that we're recommending, is it's an opportunity to focus early on some of those transferable skills that people need to be successful in life, and to some of those functional skills that go beyond reading, writing, and arithmetic, right? That kids are better prepared to face post-secondary education. So next slide. Is prior written notice. I think people probably know what this means, but prior written notice is whenever a school district or an LEA proposes to initiate or change, or refuses to initiate a change, or a student's identification, in other words, their disability categorization, or relative to an evaluation, their educational placement, or the provision of FAPE. Really, anytime the school district is proposing to do something substantial that's going to impact your child, they have an obligation to provide you with a prior written notice. The Vermont rule, and this is consistent with the federal rule, says that that proposed change, notice of the proposed change must be made within a reasonable period. We're proposing that we add the language, but not less than 14 days. So this just goes back to parents are important members of the IEP team. If important decisions are being made, they're being notified, there's been a meeting, the parents disagree with something, the school is proposing to make an important change in the way the services are delivered to their child, and the district's required to provide them with written notice. This gives the parents an opportunity to think about it, to consider it, to determine whether it is appropriate, or if not, to think about if they want to pursue some other avenue for resolving that. So that's what we're proposing. And again, it just goes back to notice. It goes back to an opportunity to be a real participant in the IEP team.
I have one other comment about this, which is when we talked earlier about informed consent for the IEP, it's usually the case that a school will send to the parents a prior written notice with the IEP. But all that does is give notice to the parents that this is what the school district is proposing. It doesn't ask for consent. And it doesn't ask for your input about the areas where you might not consent or suggestions you might want to make. So some people might say, with respect to informed consent, well, isn't it enough to get prior written notice? And the answer is no. The prior written notice serves a different function. It's just to give parents a heads up that this or that is going to be proposed.
Right, and there are requirements for what is to be included in the notice, right? The school district is required to not only say, this is what we're proposing, this is why we're proposing it. They need to make clear, what the decision is, and that, it's consistent and based on the student's IEP. I mean, they need to provide the rationale for why they're making the decision, because you can't know how to challenge something or whether to challenge something if you don't understand what the reasoning is for why the proposed change is being made.
I see a question on the written notice topic. Unless documents are written in plain English, they're not very useful. And is the written notice in the home language?
So yes, notice is to be provided in the language of the parents, right? And it should be translated if it needs to be translated. And there have been other questions sort of about the native language, and I think this person also mentioned plain English earlier is, yeah, I mean, it would be ideal if they're written in plain English. That should be across the board. But in terms of someone who speaks a different language, then yes, those documents do need to be translated or made available to the person in a way that's accessible.
And translation might mean verbal translation. It might or might not mean written translation.
Okay, next slide. This rule goes to placement. So under the current rules, under the section of least restrictive environment, which is sort of the overarching idea of least restrictive environment is that the students with disabilities are educated with their non-disabled peers, and they're educated in the homeschool to what they would be as if they didn't have a disability. So that's kind of the overarching theme of the least restrictive environment. But one aspect of that is placement, and placement is not a specific site. It's really, I think it's important for parents to understand and for educators to understand that placement really is more about the provision of special education and how and where that's going to occur. What is that provision? What is the special education that student needs, and what is that going to look like? And all of that kind of goes into the placement. So you go through the IEP process and kind of get to the end. Okay, now where and how are we going to deliver the services that we've determined the child needs? So the rules, the changes that we're proposing here are the ones that are kind of highlighted. I've italicized including parents because I just want to again reiterate how important it is that parents are part of that decision making as to the placement of their child's education. It must be made in conformity with the requirements of the least restrictive environment, that it is in the homeschool unless there's a reason for it not to be. That decision needs to be made annually. It needs to be based on the child's IEP, and it needs to be as close as possible to home. Now that's the federal language. And so I highlighted the part that says based on child's IEP, because that's the language we're proposing, which is different from the language in the current rules, which say that the placement is consistent with the child's IEP. And we do think that there's a distinction there. Like consistent with is not the same as saying, okay, you've looked at the IEP, you've made these determinations about goals and objectives, and these are the services that this child needs. Like, how are we going to ensure that the child gets those services? That it's actually based on the IEP, not just consistent with the child's IEP. So it's kind of a technical change, but we think of it as an important change. So going on to the next slide, the piece that I want to point out here in terms of placement is that, as I said, placement refers to the provision of special education and related services. And we're proposing that the language be added in the appropriate selection on the continuum of placements. And this refers to, again, a provision in the federal law that is also in Vermont regulation, which is that school districts are required to have a range of placements available for students with disabilities. And the federal regulations are clear that that could include a general ed classroom, a special school. It could be in the student's home. It could be in a hospital or another institutional setting. So the states and local educational agencies are required to have a range of placements. That's the continuum. So when a team is making a decision about what is the appropriate manner in which we're going to provide these services to the student, that you're looking at that continuum. The other thing that we're adding, and again, this goes to parent participation, is that placement decision is made by the IEP team. The current rule says that if there's a disagreement, the LEA gets to make the final decision. We're proposing that we add the language if the IEP team is unable to reach consensus. So what that does is it just sends the message again that parents are important members of the IEP team, that it's important to kind of work together, to collaborate, to get to a point where everybody's in agreement. This is how we're best going to meet this child's needs. Because that's a better outcome for everybody, right? And in particular, it's a better outcome for the child if the IEP team, including the parents, are happy with the outcome of the decision making. The question here is, does the IEP team include the student? Yes, the IEP team can. include the student. And I say can because the student, of course, has the right not to attend. They could choose not to attend. And when the student, even though the law gives the legal rights to the parents until the child turns 18, and then there's another, if a child turns 18 and still in school, then those rights transfer to the student unless the student's not able to engage in that kind of decision making. And then there does need to be some step taken to ensure that the student's rights are still protected.
I see. What age can the student join to advocate? Our rules actually don't limit this. I know in other states, they say a child should be over like 12 or 14. I've had students as young as 7 or 8 come in and at least share a little bit of their thoughts, and they might not stay for the whole meeting. But, I think it really depends on the student, whether they are ready to participate in some or all of their IEP meetings. So it could be a very young child. It could be someone who is waiting till they're 18 or 19.
There's also different ways for a younger student or any student really to participate. I have seen students submit audio recordings or video recordings of how they felt about something.
Yeah.
They really
That's a great idea.
Yeah, they really didn't want to sit there with all the adults and have everybody staring at them, but they were happy to do something on their phone or whatever and then give it to the team.
That's a great idea.
Yep.
So the next rule we're moving on to is we're proposing a MTSS rule. So I said earlier that the reason the rules are under consideration now and that they're open is because the state is changing the funding mechanism for special education. And as a result of that, the rules needed to be open in order to address the funding issues. And as I said earlier, once the rules are open, then any of the rules are open for consideration or reconsideration. But
Marilyn, before you go further, MTSS stands for Multi-Tiered Systems of Support. So when we say MTSS and we have that acronym there, that's what we're talking about.
It is. And part of the reason that this multi-tiered system of support rule is being proposed is because Act 173, which was the funding bill, focused on MTSS, multi-tiered systems of support. And there were some specific requirements in there that the legislature adopted in terms of shifting the funding was to try and provide greater flexibility to the special education system so that students could receive earlier intervention services and do that through the multi-tiered system of supports that are required to be available in every school. And they're required to be available in every school currently, but not every school is as far on that process of delivering various tiers of support for students and educational supports. But the legislation required the state to ensure that every local educational agency adopted policies and procedures. We mentioned earlier that rules have the same force and effect as law as a statute. Policies and procedures don't. So our concern is that by only requiring school districts to, individual school districts to adopt policies and procedures, we wanted to include in the rules that the state would have a model policy and the model policy would say school districts, you need to each think about this, how you're going to deliver these services, and you're going to adopt your own policies and procedures for use in your school district. But the legislation was also clear that there are aspects of a multi-tiered system of support that need to be included. And one of that is you need to be able to identify when a student is in need of the school district's multi-tiered levels of support, that you should establish, every school district should have benchmarks and to be able to measure a student's progress, one to determine when a student might need it, and one to determine when a student might need to move through the tiers, that they need a greater level of supports, to create a mechanism and a time frame for monitoring student progress on a regular basis, This is important so that students don't get placed on a tiered system and then they just kind of languish there. That we want to be looking at them regularly to see what kind of progress they're making. You know, if they're making good progress, then maybe we move them off of tiered level of supports, we modify it, we change it somehow. Again, going back to the issue of parents and parents being such an important part of this process is the ensuring that parents are informed when a student needs a greater level of supports in the schools, and are informed about the option to hold a meeting about the child, because currently that's not required, and it's some parents we've heard aren't even aware that their child is receiving services on the school's MTSS system. We're suggesting that the results of the progress monitoring be conveyed to the parents, and that there be a process by which the student's parents, I'm sorry, I'm reading it too fast, a process which includes the student's parents to determine when a student has not made adequate progress within that system and to identify appropriate next steps. So again, that might be that the child needs a greater level of supports. It may be that the child needs to move to a different tier. It may be that it's appropriate time to make a referral for a child to be evaluated for special education. So the next slide, so this is the rule, the actual rule that we're proposing. And so we'd like people to weigh in on this. Do you think this is a good idea? And if you do, then, you know, this is one of those important issues that we think the State Board of Education needs to hear from parents about. And then the other aspect of the rule is that the SEA, which is the Agency of Education, shall establish a model policy and procedure that includes best practices to ensure that the state and the local educational agencies' child find obligation is satisfied. What does that mean? What that means is that every state, and this kind of goes back to the question too that somebody was asking about sort of new Americans, is that the state has an obligation, every school district has an obligation to annually seek out and identify students who have disabilities. And that requirement would include the new American communities, that the school districts need to be reaching out to students to determine whether or not they have a disability. Another rule that we've proposed to change to is, or language we've proposed to change to, is to the child find rule. Is that, I think, is that the next slide?
I think it's next, yeah.
Okay, so the next slide is, so this kind of ties into that, is that we added a language in the child find rule, which exists currently, which is that if a student is receiving services on the MTSS, and the school district has a reason to suspect the child has a disability and is in need of special education, then they must go ahead and locate, identify, and evaluate the student in accordance with the requirements under special education. And then the second provision of that is that if the student can continue to receive those MTSS services while the evaluation is pending.
I think one of the things that's really important about this is that a child doesn't have to start being an MTSS to be evaluated and to be child found.
Right.
And I think that's something some families are maybe already struggling with in districts that do have a robust MTSS system. And it's the Act 173 that, again, is prompting all of this, was very specific that it was not intended to change any of the rights children with disabilities have under the special education laws. And one of those rights is to be put through child find, to be located, identified, and evaluated. And so having MTSS does not mean that a school district can put off identifying and evaluating students, which is what we mean when we talk about child find.
Yeah, I think Rachel just answered the question that someone sent in about what is child find.
Right.
And someone else wrote in and asked us to note that MTSS does not preclude consideration of the need or eligibility for special education. And I think it's the truth of the matter is that some students will have needs that can be met within an MTSS system and some students won't. And we need to have some kind of process here, like the one that Marilyn sketched out, where we can keep tabs on how students are doing in MTSS, whether they need to move on to something more intensive, whether they might need to have an IEP and be in special education. All the options need to stay available for the people working with the student.
Part of the reason we proposed this rule is because when some other states have made this shift in their funding mechanisms, they have also made some changes in the way in requiring school districts to have MTSS systems. And some states have kind of run afoul of the special education law by relying on MTSS and ignoring special education. And so we wanted to make sure, we think it's great, we think it's important that there be robust MTSS systems when schools. There's lots of research on why it's important and helpful to kids to be identified early, to get interventions early. Just because your child needs an intervention doesn't mean your child has a disability. But if your child does have a disability, the school district is still obligated to identify your child's need and to provide your child with the services that he or she needs. So there's a little bit of a tension there. So we wanted to make clear that school districts had mechanisms in place to ensure that kids didn't get stuck in MTSS or delayed in the delivery of special education services.
And kids can be eligible for special education and be receiving special education and also be receiving services in an MTSS system. Right. Those are not mutually exclusive. They should be working together to meet the needs of students with and without disabilities.
Did you guys see the question, what percentage of districts have a robust MTSS system?
No idea.
I'm not sure what the answer to that question is.
And somebody else had asked a question earlier about some other statistic, and I don't know that information is available.
Yeah.
I don't think the LEAs report that to the state.
Yeah, and I guess it would also turn on the definition of robust. What is a robust MTSS system? And to the person sending that question, the MTSS concept is fairly new, although there have been other things similar to it. There have been other efforts made at meeting the needs of students early without the special education system. The regular education initiative, mainstreaming, RTI, these were all efforts to do things similar to what MTSS is trying to do.
And RTI is response to intervention, which is especially a piece of looking at students who have specific learning disability.
I think the answer to the question, though, about who has a robust MTSS system is that it varies probably greatly throughout the state.
Yeah.
Next slide.
So was somebody else going to jump in here? Okay. So the other sort of new area that we're proposing, so the rule we're proposing relative to multi-tiered systems of support is a sort of a standalone rule. It wouldn't be necessarily, we're not proposing that it be included in the special education rules. We're proposing that it be included in another section of the State Board of Education's rules. So that responsibility for implementation doesn't fall on special education, because it really is a general ed, and there needs to be collaboration between general ed and special ed in some cases to make sure that students get what they need. But the other new rule that we're proposing is relative to students who live in choice districts. And part of this, the impetus behind this is that part of the Act 173 language was around independent schools. And so there are going to be some changes in terms of how independent schools operate. So it was a good opportunity to ensure that kids with disabilities have the same opportunities as kids without disabilities to enroll in independent schools and not experience any exclusion or disability based on their disability. So we took a look at the charter school language in the federal regulations. We don't have charter schools in Vermont, but other schools do. And so we took some of that language, and we also borrowed language from New Hampshire that has this language in it. And so this is like I said, a standalone rule that would address sort of ensuring that students with disabilities who are enrolled in independent schools also get their needs met. So if you happen to live in a choice district, this would be something that might be of concern to you. Part of the rule would address that, that there be an IEP meeting, that the representative of the independent school be invited to participate in that meeting. Because now, if a student is on an IEP, the IEP team makes that decision, and sometimes that decision is made without the independent school being a participant. And then it's kind of hard to know, well, what are the supports and services available within that school? When the IEP team meets, it's an opportunity again for the team to determine what is the least restrictive environment for the student, what is the best way to ensure that that child's free appropriate education needs are met in accordance with their IEP. And then we list various options for ensuring that the services are provided. And this again goes to addresses some of the unknown in the Act 173 about changes to the independent schools rules. But options for ensuring that, how we ensure that kids get schools is that, the district can send staff to the independent schools. They can contract with independent schools to provide special education services. The district can provide it at the independent school. It can transport the student to a local public high school in their community. So there's sort of a variety of ways to do that. They can provide transportation. And again, the purpose of this rule overarching is just to ensure that kids with disabilities have the same option to choose an independent school as a student without a disability. And Greg, I know you've worked with this more in New Hampshire. Is there anything you want to add to that?
Well, basically, I mean, to sort of summarize everything Marilyn said about this, if you have a student in a choice district who has special education services, you want those services to follow the student. Mm-hmm. So if the student goes to attend a different school in a choice district, that student shouldn't lose services. And also, the independent school can't necessarily provide the services. And mm-hmm. So we have to set up a system so that the services follow the child. In New Hampshire, this is easily done right now in the charter school system, where in New Hampshire, charter schools are public schools, and parents can make the choice to send their child to a charter school. And when they do that, there's a system just like this, where you have a meeting and someone from the charter school is on the team, and the whole team decides how we're going to continue to provide those services to the student. And there's a variety of ways to do it, but you make sure that it gets done one way or another.
Okay, thank you. Next slide, I think.
So, Greg, do you want to take this or?
Well, I can at least start with it. I would like to just, as Rachel did at the beginning, impress upon everyone who's listening or may listen later that this is an important time to provide your feedback to the Vermont State Board of Education and to the Vermont Agency of Education, but in the sense of public comment, it goes to the Vermont Board of Education. So that you can have a voice in the next set of special education rules that gets written for Vermont. And those rules will be in place for years, and they will affect every student with a disability. So it's a very important opportunity. And if you see any of the issues that we discussed today, if any of them are important to you because of your own student, your own child, or if they're just important to you because you think they're important for other students or students that you know, then please make a public comment, even if it's a simple email. But please do it, and please do it before the end of December, because that's the time frame. You have a chance to make a real difference in the rules.
I think, you know, too, it doesn't have to be long and involved. You know, one thing, I think we have in here a link to the, do we have a link in here in our materials to the, our proposed rules that we drafted? But, you know, they're a little bit dense, but if there's an area that you're particularly concerned about, you can take a look at the proposed rules. And they're red lines, so you can kind of see where we're making the changes, and you can see the current language with the proposed language. If you have time to do something like that, you can send an email to the State Board of Ed. They are going to have further public opportunities for public hearing. You can simply just, you know, shoot an email and say, hey, I've looked at these rules or proposed rules that legal aid is proposing, and I agree with adverse effect. And and this is how it's affected my child. It does not have to be really long or involved. I think it's important, as Greg said, is just really that the board hears from people that says, we'd like to see this change, or this is how this proposed change could affect my child, or here's how it has impacted my child in the past, and if we were to change it, then my child would be better off.
So I put a link to the survey that we have put out, VFN has put out, to get input from families, and you know, it contains obviously a subset of proposed changes, not anywhere close to everything that DLP has put in. But ones that we thought that parents might be especially interested in weighing in on. So that survey is out. I the link in the chat. We've put it out several times. And, we will take all the results and present them to the State Board of Education as well. So that is another way of doing it, but you should certainly feel free to submit input as an individual as well.
Hey, Rachel, did you mean a minute ago, like, these are elements to public comment? Were you making the point that, hey, you want to state who you are?
Yeah, I think it's helpful to say, you know, I live in Burlington and I care about special education because I have a student with a disability, or I have a cousin or a sister, or whatever the reason is that you care about it. Or I've been a special educator, and part of why I, you know, think this is important is because what I know my students have struggled with. If you're a parent or you're a student and you've experienced challenges that kind of inform why you think these things are important, I think that context can help the Board of Education really understand how these rules impact real life people. You don't have to go into a lot of detail. You don't have to share your whole life story. But giving a little bit of a kind of context, I think, can help. And then, you know, as Greg and Marilyn and Karen have said, you might just say, I agree with the changes that Vermont Legal Aid has proposed, and that's what you want to see. You might want to see different changes. You know, I think we've gotten some questions in the chat today that maybe would more robustly address issues about language access than the proposed changes that we put in. That person could absolutely bring those up as needed changes in the rules. And I think that makes a lot of sense.
I hope that person does do that.
Yeah, me too. And so you can be really specific about the changes you want to see. Like Marilyn said, we submitted what's called a redlined version, where we crossed off the things we wanted to take out and we put in red the things we wanted to add in that we've covered today. And so you're certainly, that takes a lot of time. You're allowed to do that for sure. Or you can just say, I agree, adverse effect needs to come out, or I agree, we need a stronger rule to make sure parents can fully participate. So you don't have to have the exact language that you would want the rule to say. You can share kind of the sentiment that you think the rules need to have, and that's fine too. And the board will review all of those public comments before it makes its decisions about what rules it's going to change and what rules it's going to leave as they are.
I've noticed today something that I hadn't really noticed before, just in the conversation, which is that almost all of this is about making the process more inclusive, either for the students or for the parents, in one way or another, which is really timely, you know, in a way. And none of these things are kind of crazy out there ideas. They're all very basic, common sense, simple things. And so your input to the state board can be very simple and straightforward also.
I also wanted to comment that one of the suggestions in the chat box relative to Child Find was that, you know, changing the language from continuing with MTSS while an evaluation is pending to beginning services. And that's an excellent suggestion, right? That just because a child is now being evaluated for special education doesn't mean they shouldn't also begin an MTSS, you know, some tiered supports if that's what the child needs at that moment in time. Because if that's been identified, then it should be provided.
And you might learn some things from that too.
Right.
You might learn some things from the MTSS experience.
So this slide really covers, well, how do you make public comment? And probably the easiest way for most people at this point is to send an email to the Board of Education. And the email address is sbe.publiccomment@vermont.gov. That's on the screen here. You can also write a written letter. If you're not someone who likes to email, you can send a letter. Or you can actually come to a Board of Education meeting. The meetings have been held virtually of late, as most things have, and we expect that that will be true for the next several meetings, although I haven't seen a location listed yet, so that's why we have it as TBD here. And there will be a part of the agenda, at least in October and November, that is specifically about public comment on the rules. And at all public meetings, including the December meeting, there will be a period of time that's about public comment generally. So there are opportunities to, if your easiest way of sharing your thoughts is verbally, to call in or participate by video call in a Board of Education meeting to share what your thoughts and your concerns are. And that's what those of us who are on the panel today have done in the past, is either go to a meeting or participate in a virtual meeting.
Well, I think that when the first public comment period specifically relative to the rules occurred after March. So I think we've all done our comments virtually. I wanted to point out too that the state board, the chair of the State Board of Education did indicate that they would have not just a public comment period in October and November, but actually a period, you know, designated for comments on rulemaking. So, you know, obviously during public comment, people can come and talk about anything related to public education, but here it's set aside time for the board to hear from people who care about the proposed rules. So that's a good time to call in.
I've noticed over the past little while that the State Board of Education is paying close attention to the comments being made by whoever calls in. So I think they're being very conscientious about listening. And so if you decide to make a comment, you can be sure that it's going to be considered.
I think that's true. That's certainly been my impression as well, that the board seems to be taking the concerns and comments of people very, very seriously. I think originally they were thinking it was going to be much narrower, focused just on funding relative to the changes required by Act 173, but they seem to be understanding that there's a strong connection between changes in funding and the delivery of services to students. And Janice, I think you're probably piping in because there's a question about, can we send the slides?
Yes, we are gonna send the slides.
Okay.
As well as a link to the recording. I did want to let everybody know about a couple of upcoming events that we have. We are hosting a series of focus groups with the Vermont Developmental Disabilities Council as they develop their next 5-year state plan. There's one left on October 19th for parents in Lamoille, Orange, or Washington County. But if you live in another county and you really want to participate in the focus group, please just go ahead and register, and we'll make sure that you get a chance. There's also 4 more workshops left in our Persevering in the Pandemic series, and you can find links to both the focus group and the series right on our homepage. I really want to thank our presenters today, and we're actually ending a few minutes early. which means you have time to start your letter writing or sending your email forward, so you can use that time. I did put a link to the evaluation in chat. That's also going to pop up when I close the webinar for today, and it'll come in the follow-up email. So I want to thank all of our great presenters today, and leave you with the idea that we are really here to help as our DLP and also Greg's firm. And so give us a call whenever we can be of assistance. And thanks so much for participating today. We appreciate you being here. Have a great day. Thanks, everybody.
Thank you.
Thank you.
Thank you.
Hey, guys.
Hey.